I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my serial co-host, Brett.
Serial. Exactly. I'm your first co-host, but I guess I'm also your second co-host, though I'm not your third and fourth co-host.
But you're my always co-host, but that's not the point, because today we're talking about what happens when you hire and fire serial counsel. What can happen to you, Brett?
It's a great question. And it's one that I think a lot of people probably didn't know a whole lot about, didn't realize that you could go through so many counsel that eventually you run out. There's just no more lawyers left. And then what happens when there are no more lawyers left? You have to represent yourself. And of course, we're talking about the Sarah Boone case. For those of you who've been following it, a brief sort of background on her, and then we'll jump into this interesting but not unique legal issue. This is one of those where if you've been following just the legal news or the people who don't really know what they're talking about, they act as though this is shocking and possibly unconstitutional and all sorts of other things, groundbreaking, and it's not really. So we're going to talk about it. But Sarah Boone, for those of you who don't know, is a 46-year-old Florida woman, love you Florida, but it's always you, who is accused of zipping her boyfriend, Jorge Torres, up in a suitcase and leaving him inside to die. Yes, you heard that correctly. That is the method of murder in this case. Now, Boone claims that this was all a mistake, the result of a drunken game of hide and seek that ended with her passing out while Jorge died of positional asphyxiation. And I don't want to prejudge this case and have someone accuse me of being biased. But given that there is a video, a very hard to watch video of Jorge screaming while Sarah laughs at him and tells him that this is all, a video she took on her phone, laughs at him and tells him this is all punishment for cheating on her, it would take a, dare I say it, Karen Reed level of suspension of disbelief to think she's innocent. But so far, she says she's going to trial. And typically, when you go to trial, you need a lawyer.
So, although this case might be quote-unquote boring from a factual perspective, just because it doesn't seem that there is a lot in dispute, Boone herself has made it a very interesting case from a legal perspective. And that's because she has worked her way through 8 attorneys. But the interesting thing is she won't get another one because the judge has ordered that Boone has to represent herself. And this has set off a flurry of news articles, social media posts where people say, how can this possibly be? How can it be that you have a right to counsel, yet she's not getting right to counsel because she's being ordered to represent herself? Is this punishment for what she's done? What happens if all those 8 attorneys were just bad? Is there a limit to what you can do with respect to firing your attorneys, forcing them off the case? And the answer is yes, a judge can order Boone to represent herself. And in fact, her particular fact pattern, we will walk through, but she could have been ordered to represent herself much, much, much longer ago than after 8 attorneys.
And I'll say this is one of those things where sometimes you have a textbook case that you could use in a law school classroom, and it just comes along and it's absolutely perfect. And this is the case for this issue. Now, as we've talked about before, and we actually have a Legal Briefs episode on, under the United States Constitution and under Florida state law, every person accused of a crime has a right to counsel. Now, that is a right that, if you so desire, can be waived. And that waiver must be knowing, intelligent, and voluntary. And when a defendant seeks to waive the right to counsel, a Feretta hearing is required. And so you might be thinking to yourself, well, wait a second. Alice just said that the judge ordered her to represent herself. That doesn't sound knowing and intelligent, and in particular, voluntary. That sounds like something she's being forced to do.
But here, we're not talking about waiving the right to counsel. And I think this is where people get a little bit confused when they're shouting from the rooftops, everyone has a right to counsel. Because what we're talking about is the flip side of it, forfeiting the right to counsel. We've talked about this a lot, where when there are constitutional rights, they can be waived. They're not absolute, where it's like, we've talked about speedy trial, for example. That's a constitutional right that can be waived by the defendant and is often done so. We've given you reasons for that before, why a defendant may want to waive their speedy trial rights. Even though it's provided for in the Constitution, they may want more time to do their own investigation. The volume of discovery may be so large, they want to make sure that they've gone through it all, find all the holes in the prosecution, etc. So constitutional rights are waivable or forfeitable. So in the 11th Circuit, the Federal Circuit, which oversees Florida, Georgia, and Alabama as well. In the case United States versus McLeod, this is the leading case on the issue. In McLeod, the court held that a defendant who is abusive towards counsel or who attempts to manipulate the court by virtue of their behavior towards counsel may forfeit the right to counsel altogether. Some of you may be thinking, I've heard of attorneys maybe not being great counsel to their clients. What do you mean a client can be abusive or manipulative towards their counsel? Boy, is this the fact pattern for you to see how you do that. One of the first things that comes to mind is, we've seen this in other cases, when you get a new counsel, what's something that the new counsel often files if you're about to head to trial? Can we push that trial,
motion to continue.
Judge? A motion to continue. We need more time. We just joined the case. We need to know what's going on. And almost always, the judge is not going to force that counsel to go right to trial if they just got, a massive hard drive of discovery.
And you'll all be shocked to know that when you often see a motion to replace your counsel, wouldn't you know it, it tends to be a couple days before the trial is supposed to start. There's a lot of times that is a great way to push that trial back. And that's why you often will see a situation where, in fact, and we're going to see that in this case, the judge says to someone who wants to fire their lawyer, no, you can't do that. And as we've talked about some in the Delphi case, you don't actually have a right to your choice of counsel. You have a right to counsel, but you don't have a right to choose who that counsel is if you can't afford to hire one. When we talked with Drinks with defenders and they were public defenders, and one of them mentioned this, how she doesn't get to choose her clients and they don't get to choose her. They're just assigned her. And that's the way it works when you can't afford to hire your own lawyer. So we talked about the 11th Circuit, and we talked about this before. You got the 11th Circuit is a federal court, but this is a United States constitutional issue, the right to counsel. So oftentimes, even though you're in Florida state court for the prosecution, the first place you kind of look is, what have the federal courts said about the federal constitution? Because guess what? The state courts in Florida are then going to apply that statute, and they have done that. As Florida courts have explained, antagonism and even personal attacks upon each of a lengthy series of court-appointed attorneys, all of whom were required to withdraw, rendered it obvious that the defendant simply would not permit himself to be represented by anyone, and amounted to a binding forfeiture or waiver of that right. And that's Jackson versus State, which is a 2009 Florida case. Now, look, you may be thinking, well, shoot, you must forfeit your right to counsel all the time. You guys were just talking about how abusive defendants are to their defense attorneys. No, it's not as simple as that. Like everything in the law, this isn't black or white. It's not the first time you yell at your defense counsel, all of a sudden you don't get a lawyer. Oftentimes, the relationship between counsel can be contentious. And honestly, counsel are kind of like dog bites. You always get at least one, right? You got one counsel that you just can't deal with, and you get in fights, and you fire that guy, and the court's like, you know what, we get it. First one didn't work out. We're going to give you another counsel. But if you keep getting in fights and you keep being abusive, at some point, just to keep on with the cliches, and this is one I've said before, the old saw about how if you meet an asshole in the morning, you met an asshole. If you meet an asshole every morning, you're the asshole. And that's sort of this principle here. If you have this long string of attorneys and you just can't get along with them, at some point the court's going to look at you and say, you're the problem, not the lawyers. And since you're doing this and it's so disruptive, this is going to be something where we say, sorry, that's it, no more. This is an extreme remedy. It will only be used in extreme circumstances, but courts have routinely found that a defendant who goes through 3 or 4 court-appointed attorneys has forfeited their rights. And there was a recent Florida case back in 2023 that dealt with this, KR versus Department of Child and Families, which is a family court case, but applies all of these statutes or all of these cases, all of this precedent in a really interesting way. And all of these laws, all of these cases, these constitutional principles, you end up seeing in this case. And in fact, you see it in the order that the court eventually does file in the case.
So now we know what the law says, which is that you don't have this, non-forfeitable right. But what about as it applies to the Boone case? Because that's what you always do, right? We live in a common law system where you have legal reasoning from courts and then you have to apply the rationale to the facts of your case. So does the Boone case meet the standard that has been articulated by the 11th Circuit? So since Jorge's death in February of 2020, Sarah has gone through a total of 8 attorneys, 7 of which were court appointed. So and we're going to walk through each of these to kind of show you the type of extreme behavior that would warrant this extreme remedy. So the first counsel withdrew after Sarah retained this one as counsel, which is perfectly normal. That can happen. Honestly, a lot of people may go through 1 or even 2 attorneys because of scheduling or whatnot. But from this point forward, it gets weird. So hired counsel Mauricio Padilla represented Boone for 2 years. Padilla said that there were irreconcilable differences between he and Boone, which is the reason for withdrawing. Typically, you have to give some sort of good cause reason to show that you're just not dropping them for whatever reason.
Having a lawyer is kind of like being married. So sometimes when you have irreconcilable differences, the only option is divorce.
Yes, absolutely. And just like marriage, you also have the attorney-client privilege. So anyways, Padilla was short on the details for fear of violating his duties to Boone, but he said that their relationship had become so adversarial that he could no longer represent her. And that is a typical reason you'll see why the irreconcilable differences is so important, because you have to be an effective advocate for your client. But if you guys are at odds at all times, then you can't really properly represent them. And so this is Padilla's reason for needing to step off the case. And he filed a second motion where he expressed ethical concerns about representing Boone, and she expressed her desire to fire him. So now we have both sides wanting this attorney divorce. So the state put on notice that it was concerned about a potential strategy of firing the counsel to delay trial. And the court did reiterate those same concerns, but allowed Padilla to withdraw and appointed a third counsel, this time a public defender.
So she hires this first counsel. So she initially, and this happens all the time, you're appointed an initial counsel. You do sort of your arraignment, your initial appearance, maybe your detention or your bond hearing, that sort of thing. And typically, unless you're just somebody who has a lawyer on call, right, or this is like some sort of white-collar fraud case, and you're about to get arrested, so you hire a lawyer. If you're just arrested by the police for murder, typically you don't have a lawyer. So usually public defenders, that sort of thing, they're on standby, they're on call, they come in, they represent you, you hire somebody, they give you a high five, they go on to their next client. Now you have your attorney. She has this guy for quite some time, then it doesn't work out. Well, she apparently doesn't have enough money to hire somebody else. And listen, this is actually pretty significant, and I think is a window into what was going on in this relationship. I mean, notice he had to file 2 motions. Typically, the court really doesn't like it when a defendant has to spend a lot of money to hire a lawyer, has that person as their lawyer for a while, and then the lawyer tries to get out. Really for any reason, including that the client's run out of money. I mean, there's sort of a, look, when you hired them, you entered into the deal, you told them to pay you so much, they paid you. Now it turns out you didn't quite value your time enough. Sorry, we're going to have to figure something out, but we're not going to let you out of the case, right? The court doesn't like that. So the fact that the court allowed this to happen shows you that things really had fallen apart. So now the court's having to appoint this public defender who was counsel number 3. This person lasted about a month before she too moved to withdraw. Now, this is most likely a conflict issue, not a they can't get along issue. We don't really know. It's presented as a conflict issue. Conflict just means there's something about her or about the case or about the body that this lawyer is a part of that means they can't represent her. So imagine, for instance, this happens a lot of times in, say, a multi-defendant case. You have 4 defendants who are all charged with maybe a drug conspiracy. Public defender is appointed for defendant 1. Defendant 2, if they should get appointed the same public defender's office, that case, they will say, hey, we have to withdraw because we have a conflict because we're representing defendant number 1, and it's possible that defendant number 2's defense is going to be in conflict with that, so we need to pull out of that case. So that happens a lot. So let's just grant her that this is maybe just that. So the court allows that and now appoints the Office of Criminal Conduct and Civil Regional Counsel. They last all of 3 days before moving to withdraw, also citing a conflict. Now, I don't really know what the conflict would be in this sort of pretty straightforward murder case that you would have multiple public defender's offices who are saying, we have a conflict, we're going to have to get out of this one. But the thing about these conflicts, this is all ex parte. It's behind closed doors, so we don't know what it is. We just know that the court, without comment, allowed these attorneys to withdraw. At this point, though, we've kind of run through the public defenders. So now we're going to have to start appointing private counsel. This often happens when the public defenders either aren't available or conflicted out.
And just so you know how payment works for all of these, obviously when you retain counsel, you pay for them, usually hourly or something like that. Public defenders are funded by tax dollars, so it's not necessarily coming out of a budget for either the defendant or for the court. But when you kind of run out of your public defender options and the court has to appoint private counsel, that does come out of a budget, and the court literally pays someone to do it. So it gets very expensive over time. And of course, where does that money come from? Also taxpayer dollars. So this is not a costless thing. And it's important to remember kind of where this money comes from, and it really starts to add up after a while.
So at this point, we're to counsel number 5. This is Mark Counsel. He is a private attorney appointed for the purpose of defending Boone. Now, he lasts about a month, and he also withdraws, and once again, it cites sort of a conflict issue. I don't know what's going on with these conflicts.
So we don't know any of these, but I know some of you are thinking like, what could this possibly be? Just to give you some examples of things I've seen, especially because all of these people are stepping off so quickly. Things I have seen in court that can lead the court to not question and let these counsel step off so quickly is if, for example, the defendant completely stonewalls the attorney and won't talk to them. Like, I had a defendant who was somewhat like Boone, went through like 6 or 7 attorneys. And what this person did was she was a woman and she claimed that she would not talk to men. And a lot of attorneys are men. And so she literally, like, the counsel were like, she won't talk to me. I pick up the phone. She literally won't answer my call. I show up at her jail cell. She literally turns her back to me. I cannot communicate with her. Like, I cannot represent her because she refuses to acknowledge that I exist in the room and we're not having conversation. The judge is like, yeah, you can't really represent them. That's one extreme example. But with all these conflicts, I don't think it's that she has a witness or something in her case that all of these people have previously represented, and that's why they're conflicted out. I think it's probably something relational or lack of relation that is making representation near impossible.
So the next counsel is number 6. Now he's going to be our next significant counsel. He is Frank Bankowitz. Now, Bankowitz, he makes it about 6 months to December of 2022. Remember, the murder happened in February of 2020. So now we're over 2 years later. And at that point, he files a motion to withdraw once again for irreconcilable differences. He says that Boone was an entirely unreasonable client, that she would call him 5 to 10 times a day, and that she could never be satisfied no matter what he did for her. Boone, called him a liar, not great, and said she wanted him removed too. At this point, the court warned Boone about the limitations of representation and denied the motion. So essentially said, look, the court's basically like, look, lady, we are starting to tread into you're getting close to forfeiting your right to counsel thing. And you don't get a perfect lawyer or the lawyer that you love or the lawyer that will answer all your questions. I mean, look, at the end of the day, whether you think it's fair or not, money still matters in the legal system. If you are rich and you can hire an attorney and basically tell him, look, I will pay you enough money that you are my guy till this is finished. You're not representing anybody else. You're on call all the time. And that's what you're going to do. If you can do that, good for you. But if you're in a situation where you have this kind of counsel, he needs to work diligently and he needs to provide good representation to you. But he has other clients too. And the amount of money he's getting paid by the state is not going to keep his doors open or food on his family's table. So he needs to be working for his other clients as well. And what he's basically saying is the fact that I'm not giving her basically my entire life, she screams and yells at me and hates me and is calling me a liar. But the court, they warn her and then they deny the motion. And this goes back to something we said earlier. You don't get to choose your lawyer. So at this point, we're on number 6. The court is getting a little sick of this and is saying, you have a good lawyer. And you often see this in these cases. We see this all the time. The judge will say something like, I have had Mr. Bankowitz in front of me 100 times. He's tried 27 cases in front of me. And let me tell you, he is a great lawyer. He is put together. He knows his cases. He will represent you well. You should be happy with him. You need to work this out. They'll say something like that.
But Boone wasn't satisfied. Boone wants to make this as difficult as possible for her attorney. So she actually ends up writing 6 letters to the court that the court itself described as ad hominem attacks on Bankowitz's professionalism and morals. So fast forward about 8 months, by August 2023, Bankowitz is like, I know, court, you already denied my motion to withdraw, but he files another motion to withdraw. And he further tells the court that Boone would only be satisfied by an attorney that could dedicate all of their time to Boone, kind of like really what he said in the first motion. And he suggested even that she should represent herself. Boone had called Bankowitz a dud, a buffoon, and she constantly berated him. At this point, the court had seen all those letters, had seen kind of 2 desperate motions from Bankowitz. And so the court does allow Bankowitz to withdraw, does not yet, at this point, order Boone to represent herself. Although, if you're looking at this fact pattern, I think under 11th Circuit case law, the court would have been absolutely justified in doing so. But the court here appoints a 7th attorney, Winston Hobson.
So the court warns Boone at this point and says, look, I am reaching the limits of my patience. And basically says, if you can't make peace with an attorney, you're going to have to represent yourself or hire counsel. That is always an option. If you can come up with the money to go out and hire a counsel, good luck to you. Like, you can have whoever you want. But if it's going to be a state-provided counsel, you need to work with this person. You need to respect this person. And you need to let them represent you. By February of 2024, Hobson has moved to withdraw, citing, once again, irreconcilable differences. The court grants the motion and says to Boone, I've already warned you, but you talk about bending over backwards. This is the most flexible judge ever. I mean, this is a judge who, can put their hands on the floor while standing up. I mean, this is amazing because, frankly, in the courts that we practice in, you would not get to this many have gotten to this point, right? But nevertheless, the court's like, I am giving you one more chance. Attorney number 8, Patricia Cashman, is now appointed to represent Boone. This is in February of 2024. By June, Boone was calling Cashman a liar in a 58-page letter to the judge, at which point Cashman moved to withdraw, which, it's great when you create a record. You really love having a record because you assume at some point there's going to be an appeal here. And man, there's going to be a lot of evidence to point to if whoever has to deal with that appeal on the other side.
Yeah, I just want to remind you to the case that we talked about earlier today that is on point for this particular case. The 11th Circuit said after 3 or 4 appointed attorneys, that basically gets to the point where you forfeited your right to counsel. We're at 8 now. So this is literally double what the 11th Circuit has said meets the standard of having forfeited your right. And just like Brett said, I mean, it's not just the attorney's words, even though their stories all seem very similar. You literally have Boone's own words, where she's saying, I don't want this person. They're a liar. They're a buffoon. They're X, Y, and Z, to show that it really, you can see where the irreconcilable differences come in. You can see why these attorneys are asking to withdraw. It doesn't seem like a tenable relationship, and it doesn't seem like they can properly represent her if that is the type of client and the type of insult she's throwing at her own counsel.
And let me just say this. The patience, the long-suffering judge here, it's not just because this judge in their heart burns a love of the right to counsel. It's because there is nothing worse than trying a case with a pro se litigant. The judge doesn't want it. The prosecutor doesn't want it. Sarah Boone shouldn't want it. The jury doesn't want it. Nobody, the court reporter doesn't want it. Nobody wants it. It is going to be a nightmare to have to do this. And so the court is trying desperately to convince her to just get along with a lawyer long enough to get through this. But it doesn't work.
Oh boy, does it not work. So I can just feel all the face palms by the court. The court's like, I've tried everything. This is going to be so painful because with someone like Boone, it's going to go to trial, right? Like, it's absolutely going to go to trial. And what happens when you go to trial and you don't have counsel is the judge typically has to just explain everything to you. So you guys have watched trials on TV, and even if it looks like it takes a long time, people know the rules and they know things like objection, sit down. Imagine if every single word uttered out of one side's mouth, they then followed up with, wait, what does that mean? What if they object? Could I come over now? And then, but I didn't want to do that. I said out there I wanted to. Don't say that in front of the jury. But I get to speak. I have a right to speak. I mean, you can just imagine. We've seen this in court. It is just horrendous. A one-day trial can easily be multiple weeks, and there will be so many issues that's messy and no one knows what's happening. The jury doesn't know what's happening, that it is just an utter mess of the justice system. This is why the judge doesn't want Boone to represent herself. And I mention this because I see a lot of people or commentators saying the judge is punishing her. The judge is the one punished here if Boone has to represent herself. And I want to make that very clear. So is everyone involved. The victim, the jurors who have to sit through this, really the judge, because the judge has to be the one to keep control of the courtroom. But it is bad for everyone. So don't believe it when someone's like, oh, the judge is punishing Boone, because the only one punished really is everybody else but Boone. So the court, unsurprisingly, grants Cashman's motion to withdraw. And at this point, finally, the court finds Boone has forfeited her right to counsel. Again, having gone through twice the number of attorneys that the 11th Circuit said is really enough to find forfeiture. On August 5th, the court also denied a motion for standby counsel for Boone. So even when you represent yourself, oftentimes an attorney will be appointed to stand by. Quite literally, they don't represent you, but they stand by to answer your questions. They're like your life coach in the courtroom. So if you're in trial and you have standby counsel, they usually don't even sit right by you at counsel's table. They may sit to the side, and you may turn to them and be like, can I object here? Or like, what does the judge mean when he says it's time for me to rest? What does resting mean? You know, things like that. So it's like a law dictionary. And the judge even denied that. So when Boone said she no longer wanted to be pro se, play stupid games, win stupid prizes, she's like, wait a second, this is not what I wanted. The judge said that her motion to reconsider was, quote, denied, period. And you can see videos of her. She's talking to the judge and she's saying things like, well, I don't know anything about the law. Well, yeah, that's why you were appointed counsel. But this has delayed everything so long, and you are literally the one who's made it unworkable. Like, you've been warned. It's not like this is coming out of the blue. It's not going to be different with a ninth counsel. That's the thing here, right? It will not be different with a ninth or 10th counsel. She's had men, she's had women, she's had public defenders, she's had private counsel. She's paid for counsel. The court has paid for counsel. It doesn't matter. This is not like a Three Bears situation. There's not going to be a just right fit. She's the problem.
And anybody out there who has children, you have experienced this, where you have told your kids over and over again, you have warned them, you have tried to express to them in a rational, reasonable way why the thing that they are doing is not the right thing to do and will cause them pain in the end. And they don't believe you. You know, you keep telling them the stove's hot. Don't touch the hot. Don't touch the stove. It's going to burn you. It's going to burn you. It's going to burn you. Don't touch the stove. And it's like they just are drawn to it, right? And then they touch the stove and they get hurt. And they're like, oh, that hurt. Ah, you know, and you're like, I told you, if you touch the stove, it was going to be hot. And you just feel this with the judge. The judge is like, I told you over and over and over again that you needed a lawyer and you just wouldn't listen. And now you've touched the stove and you burned yourself and there's no going back. It's over. I'm not giving you another one. And that's sort of where we're at with this case. And it's a situation where this is going to go to trial. I think it's set for October and October. I could be wrong about that. Set for trial in October. But if this one's on television, which I think it will be televised, I mean, watch it, because it's going to be an absolute train wreck. It really is. And it's not good for anybody. And if you're a prosecutor in that circumstance, you get in this really weird situation where you're not the defense attorney for the other person, but there are times where you find yourself standing up almost to object to what the defendant is saying, not because it's prejudicial to you, but because it's so prejudicial to them that you want the judge to kind of warn them, like, hey, maybe you shouldn't go down that path. That's going to open the door to introduce all this evidence that wouldn't otherwise be relevant. You know, you have that situation, and you're going to see that with the prosecutor, and they just have to kind of soldier through, present their evidence, whatever craziness is going on at counsel table for the defense, just keep moving forward, put your case out. I mean, the good thing is it's still your burden, still the prosecution's burden. They still have to prove the case. If they don't prove their case, it doesn't matter what she does or says, because she should be acquitted if they don't put on enough evidence to convict her. So what you're going to see, it is still going to be justice. It's just going to make you question how anyone involved in the case remained sane till the end of it.
Yeah, some of you may be thinking, well, maybe she's trying to make it so crazy so that no conviction can stick. No, it absolutely can stick if the prosecution does its job. And I mean, the video is literally on her own phone of her shooting the video of him begging for help and her laughing at him. So there's like, the evidence is there to convict her. And what we mean by a headache for everyone else is we'll get there, because the judge will make sure it's there. The prosecution will make sure that all the right things are done. But imagine like you're with a toddler and your job is to walk from the parking spot to the store. And your toddler is literally throwing goldfish and running out in the street, jumping their full face into a puddle as a car is ripping by. Most likely, you're going to make it to the store. But the path from the car to the store is going to be circuitous. You're going to be ripping your hair out. Everyone's going to be crying. But you're going to make it to the store. This conviction is going to stick just because she's going to act crazy, and the path to conviction is going to be a waste of the court's resources and a waste of taxpayer dollars, because it will drag on probably 5 times longer than it should. A waste of all the jurors who have to sit there because they have to sit there 5 times longer than otherwise. Doesn't make the conviction, if the evidence is all there, any less likely to stick.
Right. And to add on to that a little bit, because Sophie asked the question, it always gets asked in these pro se cases, can you have an ineffective assistance of counsel claim when you're your own counsel? No, because your constitutional right is to effective counsel. That's what you're right. That's what you have the right to. You can waive that right. you can forfeit that right. And when you forfeit or waive the right to counsel, you're waiving the right to effective representation. Whatever happens after that is on you. So once she forfeited her right to counsel, she can't then argue, well, I was so bad in what I did that I should get another trial, because clearly that couldn't have been a constitutional conviction when my lawyer was such a complete moron, right? Like, it doesn't work that way. Once it's gone in its entirety. And the only question will be, and it will be a question, I mean, this will be raised. I mean, a couple oral arguments ago, I had this case, but it was where a defendant waived their right to counsel and then represented themselves. And then there was a challenge to that. And the challenge to that was whether their waiver was knowing and voluntary. The question here will be whether or not her disdain for all her lawyers, her conduct rose to the level of forfeiting her right. And that is a abuse of discretion type standard. Did the judge actually take all this into account? Did they apply the correct standard? Did they build a record? And this judge has done that. And there is just volumes of evidence about this relationship. This wasn't a one-off thing. When you get to 8, there is no way when you're on your 8th counsel, when your trial ends, that you're then going to be able to argue that the judge was unreasonable in saying you forfeited your right to counsel and now you have to represent yourself.
Hopefully that clarifies some things, because I will say it's funny how I didn't know much about this case before we looked into all the reasons that she went through her 8 counsel. But the only thing I saw in the media was she's being punished to represent herself. This is not constitutional. That's really the only media I saw. So maybe there's other media out there that's actually explaining the situation. But hopefully you have a better idea of what the legal standards are and how this judge really more than gave her enough rope in this situation. And she has truly abused all of the goodwill of the court. And we are now headed towards probably a train wreck of a trial, which is to no fault of the court or any of the 8 counsel who've represented her.
Exactly. And we will continue to follow this case. And as it develops, if anything interesting happens, we'll probably watch it. I doubt we're going to do a 9-part series on the Sarah Boone trial, but maybe when it's over.
It will be a 9-part thing on TV, and we can condense it to probably 30 minutes.
There you go. We'll do 1 part for each lawyer. It'll be an 8-part series for each one. Okay, so changing gears completely. As you guys know, on this podcast and on our other podcasts, The Prosecutors, we try to be, at least, very conscientious when it comes to victims and victims' families. We want to be respectful of victims' families and present them in the best light while also dealing with the facts of the case. And I think we typically do that, but now I think there's an exception to that, and I want to address that. And that's the Maura Murray case. So way back 250 episodes ago of our other podcast, we addressed the Maura Murray case. And in that case, we were, and I say we, this is really me, I was critical of the family in some ways. Questioning of Maura's father, his truthfulness, how he had approached the case, whether or not he was attempting to hide information. And that was based in large part on an incident that occurred in the mid-2000s when there was a reward that was put out for information leading to Maura, helping to find Maura. And there was a story that when that tip line was established and when that reward was established, that Maura Murray's father, Fred, had put certain requirements on that, very strange requirements, including that all information would go to him before it would go to the police, that he would see the tips, that he would vet the tips, and that only if he allowed it would those tips go to the police. And it was so egregious. This is how the story went. These requirements were so egregious that the entity that sponsored the reward eventually pulled the reward because they'd never seen anything like that and they didn't feel comfortable with it, and so they pulled the reward. And this was a big fact for me because it made me question a lot of things. And I think if you've listened to our podcast and listened to how we addressed it, you will hear that doubt in me, particularly about the family. Well, recently we learned that the person who was behind that reward and behind that story is someone named LaDonna Humphrey. And I don't know if you guys have been following the Who's Afraid of LaDonna Humphrey podcast on the Pretend podcast. It's this season of the Pretend podcast. But if you have, you know it is a roller coaster unlike any other. I recommend you listen to it. There are a lot of accusations made against LaDonna Humphrey. I don't know if they're true or not. I don't know anything about most of them. But I do know about the Maura Murray case, and I do know Julie Murray, and I have spoken to Julie Murray. And when Julie Murray says in that podcast that was a lie and that didn't happen, and that how LaDonna Humphrey phrased that to various people that she told that story to, that it wasn't true, and that in fact she had doctored certain emails about it, I believe Julie Murray. I believe her when she says that, and it was shocking to hear it, and it completely changed the way I view that case. I don't know what happened tomorrow. I don't know that we'll ever know. I hope we do. I don't know that it changes a lot of the things I do think about it as far as what happened and what she did. But it absolutely changes my view of the family, and I feel really terrible, frankly, about how I addressed the family and how I presented the family. And I feel like it was a failure on my part. So I want to apologize for that to the family. I've already done that privately, but I wanted to do it publicly because I think people need to know that a lot of that information on which we may have based some of our views and the way we approached the family of a woman who has now been missing for over 20 years, who went through just immense pain. The fact that they were victimized in this way just really affected me, and it was something I wanted to talk about. So, I will try and do better. It's me. This was all me. This Allison, everything to do with this. So I wanted to apologize, and I hope that the family will accept that apology.
Wow, that was really kind of you to say that here, but I don't know that the blame lies with you because it took several years for lies to come out. But this goes to the bigger picture that we've talked about really for the last several months, how one person who's able to spout out a lot of misinformation can lead to incredible damage to real people. So this really falls in line with what we've said elsewhere. Now, we're talking about intentional lying, doctoring of emails, which is very, very intentional is the best thing I can say. There was no mistake about it. But I think this is also important. When we do our research, we always try to make sure that we have vetted our research and that we are looking at trustworthy sources. And for the most part, I think we do a good job of that. But when you are duped repeatedly, it's good to make others aware so that we are not all reading the same lies.
Yeah, and like I said, that podcast is controversial. Obviously, there are a lot of people in it who have, I don't know how reliable everybody is. I just don't know. I mean, I can't tell you who's telling the truth and who's not. But what I can tell you for certain is that when I heard Julie Murray talk about it, I absolutely believed her. And that was a thing that affected me. I mean, I literally, I was doing something, and as I listened to this part of the podcast, I just sat down in the middle of the floor because I was so affected by it, both just blown away by what I was hearing, but also feeling sort of the weight of what it meant for this case that's meant so much to me, has meant so much to so many people. And it's just incredible to see how far the reach of certain lies can go. So I recommend you listen to the podcast. Make your own decisions. You can make your own decisions about that episode of the podcast and everything else that's in it. Obviously, there are two sides to that story. As we always say, listen to both sides. But I have a feeling I know what you're going to think when you come out the end of that journey. So, okay. Alice, do you want to do a question now that we've been all serious? Do you want to try and lighten things up?
Yes, of course.
Okay, let's do a question. So those of you who know, whether it's this podcast or the prosecutor's podcast, if you do a 5-star review and you leave a question, we will answer those questions for you live and on air. So that's what we're going to do right now. And the great thing about Legal Briefs is, there are currently, 345 questions. So we have 345 total questions. We answered some of them, but there's nowhere near as many Legal Briefs questions
thousands.
As there are. Yes.
Yeah.
Okay, this is Miss Eden Hish TV. I don't know. You guys with your names. This person wants to know, if either of you were going to commit a crime, knowing that the other would be prosecuting you, what crime would it be? And how do you think you would be able to win in court?
I know it.
Oh, you do? Okay, I'm interested.
My crime would be breaking out of jail, because I know that Brett thinks you get the right to break out of jail. And if you get away, then you get to get away with it. So boom, that was easy.
Got me. Man.
For those of you who've missed Brett's utter lack of rule of law, something I didn't know about him, something that completely changes the way I view my friend, my once friend, who I thought we upheld Lady Justice's rule of law together, but apparently I'm holding it up alone, and he's trying to undercut me. He said in a previous episode that if you try to escape from jail, and you do, then that's your American right to do so. So that is the crime that I would commit. But I guess I'd have to get in jail first.
I mean, look, I believe in every human being's right to seek freedom, to seek to escape, even if you're justly incarcerated. The desire to be free is in the heart of every man and woman. So, I just feel like it's part of the game. Like, if you can't build a prison that can keep me inside, I should be able to break out of it, and it's on you for not doing a better job. That's what I think. Now, look, if you commit other crimes, like if you steal a car or rob somebody or shoot somebody or something else, you can be prosecuted for that. But the simple act of escaping, like those
Stop
four guys
digging the hole,
in
stop
Alcatraz,
digging the hole.
Whatever.
Answer this question. What would you commit
The
if I
people are
represented
with
you?
me on this, Alice.
I
You
don't
think
know, man.
they're with you. They're
I
not
don't
with
know.
you. They're not with you. They all seen Shawshank Redemption.
That was just an opportunity for me to twist the knife a little bit. So what about you?
I'm going to say this, and hopefully nobody's listening because I don't want to get, fired. But the fact of the
I'm the one who
matter
could fire
is
you.
that there are certain crimes for which there's like a threshold where if you don't get over the threshold, you don't really get prosecuted. So what I would do...
We're not going to tell you what the thresholds are.
We're not going to tell you which ones they are or what the thresholds are. But what I would do is I would steal just under the threshold. And that way, Alice would never actually be able to prosecute me, and I would be able to defeat her because I would not have to go up against her in trial, because everybody knows that if I had to go up against Alice in trial, I would invariably be defeated. So that's going to be my... That's going to be my
You would
thing.
not invariably be defeated, but you're right. Just so you know, we're not going to tell you what the thresholds are, and it's different by jurisdiction. But, I could totally see Brett being like, Alice is too lazy to prosecute 3 robberies, so I'm going to do just 3, not 3.5 or 4, just 3 robberies. That's it.
There you go. There you go. Well,
That's a good. That was a really. That
was
good
a great
question.
and look, you guys leave a lot of very serious questions, and we appreciate serious questions, and we're happy to answer serious questions because we're serious people, despite what you might see. So keep bringing them. But we do love the funny ones. So if you can come up with the sort of lighthearted ones that are nice to have after very serious conversations, those are the best. And frankly, you probably will go to the top if you leave a funnier question, whether it's on Legal Briefs or the prosecutors. But we're going to get to all of them eventually. If we do this long enough,
might take
we'll
300 episodes.
It may. It may.
Well, this has been a lot of fun, as always. Thank you guys for asking these questions. I really enjoy kind of digging into these types of questions you guys have. And I learned something new about your right to forfeit counsel and this particular case. And we're definitely going to follow it because it's not going away anytime soon. But keep telling us what you want to hear about. You can write to us at prosecutorspod@gmail.com. You can reach us on social media. We're on X, Twitter, I still don't know what to call it, TikTok, Instagram, Facebook. You can join our fan-run Facebook discussion group, The Gallery, on Facebook. They are always having really great discussions about these types of cases and where a lot of these ideas come from. With that, Brett, is there anything you'd like to add before we sign off for the day?
That's all I got for today. Thank you guys, as always, for giving us ideas for Legal Briefs topics, because it's really valuable. We'll never run out of prosecutors' topics. But every now and then with Legal Briefs, I'm like, what are we going to talk about this week? I don't know. So if you have questions, and this is one a lot of people asked us about, so thank you for that. If you have questions, shoot them to us.
Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. A food-related injury?
Only if you want all these people to hear it, too.
So, of course, I had Buc-ee's chocolate-covered almonds in the car. We talked yesterday about how it's like 100 degrees here. So of course, it melted. I have one big thing, so I was like, well, I could have thrown it away, or I could put it in the fridge and try to save it. But when you do that, then it's just one mass thing of chocolate. And it's been that way for like a couple months now.
Hammers.
So I was looking at it today. I hammered it. And pieces of almonds flew into my eye.
Oh, no.